No, I don't need it. So let's take a step back. We've heard a lot today what lawyers do, what are lawyers, but I think at heart, what lawyers do, they help make decisions. They help their clients make decisions and make decisions among themselves. My talk today looks at how data and analyzing data can help lawyers make decisions. At the most basic level, all lawyers do is help clients figure out what's a court going to do. Given a set of facts, what will a court do? What does a statute say? What does the precedent say? Everything we do is figuring out how will courts operate. Holmes recognized this over a century ago. But in many respects, the way that lawyers achieve this hasn't changed much in 100 years. Sure, we have things like Lexis and Westlaw and Bloomberg, and we can do searches, but we're effectively throwing a dart and hoping we find some sort of case or precedent that helps us make the decision. There's a famous Norman Rockwell painting from 1927. But we heard Richard Sussman talk before. There's certain disruptive technologies that are going to kind of change how we do this. And that's kind of what my talk will be about today. First, a brief moment to pay tribute to Larry Ripstein, who was a giant in his field. Prior to his death a few months ago, he published this amazing article, Law's Information Revolution, which looks at how data can transform the way we look at law. And it's done through what we call disruptive technologies. Disruptive technologies, Richard talked about, change the way we look at how law works. Now I'm going to talk about one tool which I developed called Fancy SCOTUS. And for my friends in the UK, SCOTUS stands for Supreme Court of the United States, no dirty thoughts. And this is a Supreme Court Fancy League, which I developed about 3 years ago. What does this mean? People make predictions on how the justices will vote on the cases, and based on this, we actually crowdsource a prediction market. And we offer very accurate predictions on how the court will decide cases. This is really but one of the first tools in trying to figure out how will courts decide. And we do this based on the wisdom of the crowds. It's a wonderful book by James Suwick, if you haven't heard of it. By looking at the wisdom of 100,000 people, you can get more accurate results than you would from just a single expert. And by looking at how the crowds think, we can get very, very reliable predictions. So how does it work? Very simple. You predict how the justice will vote. And we had a big Supreme Court case the other day, which I'll talk about in a second. But it's a very simple game. We have over 13,000 people playing it at law schools across the country. I think a number of the law students here actually might have heard of it. It's very popular. It's been featured in the New York Times, Wall Street Journal, CNN, ABA Journal, Yahoo. We've been all over the place. For the simple reasons that we're the only product on the market that offers detailed predictions about the Supreme Court will resolve every case before it. And here's what it looks like. This is what we have. We have the wisdom of the crowds. For every case the Supreme Court considered, we say, what's going to happen? Will it affirm or reverse the lower court? And then after it's over, we say, were we correct or not? More often than not, we're correct. We're about 70% accurate, although frankly, our best predictor is about 80% accurate, which is better than any expert. If there are any law professors in the room, you'll see it's very difficult to pin a law professor down and make a prediction. They always waffle and equivocate. Here we have something solid. Now let's talk about a big case. Now, note, I made these slides about 2 weeks ago before the healthcare case was decided. But I think what's somewhat revealing is that we didn't have a solid answer. We had about 56% said that the Supreme Court would strike down President Obama's healthcare law, about 40 for a poll. We weren't confident about that. We never had significant data to make any results. Intrade had it at 70% strike down. They were dead wrong. And I think our data actually reflects the fact that people were just uncertain of what the court will do. And in some cases, uncertainty is just as useful as certainty. One interesting trend also is when we start looking at the law as data, we can do cool things like this. We did a daily tracking poll of how the court was perceived on a day-by-day basis. This red line up here was the day the Supreme Court heard arguments. And if you look, right after the arguments were heard, it kind of shot right up. Then it leveled off. And then it shot up a little bit more, and then kind of leveled off. But it never really went much above 55, 56% during the entire game. And really, even though we had over 400 predictions, by the end we were just not certain how it works. But really, the Supreme Court is just a starting point. Although I find the Supreme Court personally interesting because I'm a big constitutional law nerd, it's not really relevant. Most lawyers who you deal with the lower courts. In the United States, we have tiers of courts. We have trial courts, we have courts of appeals, we have the tippy-top Supreme Court. What would be really interesting to lawyers and non-lawyers is how lower courts will analyze stuff. The issues aren't as politicized, they're not as controversial, and there's a lot more simple things that affect people. So we see inherent limitations in crowdsourcing because you have to have people familiar with the cases for it to work. If people aren't familiar with the cases, crowdsourcing fails. So what do we do next? What comes after crowdsourcing? Data. And how do we get it? Through something I call assisted decision making. This is using data about cases and how cases are litigated to help make decisions, help make predictions about how courts will treat different circumstances. And how do we get there? What we call super crunching. Has anyone ever seen this book by Ian Ayres? It's a wonderful book called Super Crunchers. It basically transforms the way you'll think about data. They had this really cool experiment where they had people who grew wine, for example. And you have these people who would predict, grew grapes, you don't grow wine. But people who grew grapes would try and predict, based on certain conditions, how much a vintage would cost. These other scientists built an algorithm saying, okay, based on the weather factors, based on soil conditions, we're going to predict that this vintage will be of a certain value. The computers destroyed the growers of grapes. They destroyed them. And the growers of grapes, as you might expect, rebelled, said, we can't trust these computers, these aren't reliable. If you see any similarities to what will happen in the law, you should, because it's exactly the same thing. Individual lawyers are experts in their own specific fields, but their knowledge is inherently limited. What we have to do is take all of the law, understand as data, and like computers, not associates, not exports, technology, grasp it, and crunch it, and figure out what we're going to do. Now, how do we do this? This is a product which I hope some of you are familiar with, but many of you might absolutely hate it. In the United States, we have something called PACER, which has every single federal document that's in any federal court stored online. It's this massive repository. And unlike our good friends at the National Archives in England, we're trying to open source it, PACER is the exact opposite. It's totally closed sourced. Not only is it closed sourced, it's not free. Believe it or not, if you want to download a document from the federal courts in the United States, you have to pay 8 and now 10 cents a page. They charge per page to download a document, which is, it's beyond preposterous. I can't even fathom why it's there, but it's a very good moneymaker. It's a very good moneymaker for the courts, so they like it. But the information is there. And unfortunately, there are a lot of good resources like Public Resources and Recap, which have kind of taken a lot of this information and brought it down into a free place. So with this information, we can actually learn a lot. Now, PACER looks something like this. I'm not going to bother going through it right now, but all the information is kind of in one table with random links, and everything's kind of hodgepodge. Even if you have the most sophisticated scraper, it's going to be very difficult to kind of make sense of this and kind of learn how to put this into data. I can only describe PACER as a data drain. The ones and zeros go right down the drain, and all we get are these PDFs, which are very difficult to read. Dan and Renee do some great work kind of parsing them, but you're just limited in what you can do. So what I propose and what I suggest is kind of viewing law as data. And this is really what Richard was getting at. And one of my favorite movies, I don't know about you guys, is The Matrix. And one of the coolest scenes in the movie is when Neo gets it. He starts looking at the agents and he's like, those aren't agents, those are ones and zeros. Those are binary. And I think that's something which the people in this room have to kind of help lawyers with. Kind of saying, when we're looking at that kind of docket, we're not just looking at PDFs and links and rules of law, we're looking at data. There are facts, there are patterns, there are trends which can be discerned quite easily. And I'm just going to walk you through it. So let's look at a simple thing like this. This is just the header of a data, right? What can we learn from here? Okay, we have Oracle v. Google. This is a very big IP case. So who are the parties? Oracle and Google. Who's the judge? Judge Alsop. What kind of case? Patent infringement. When was the case filed? August 12th. Was there a jury? Yes. What kind of suit? It's a patent case. So just from that, there are a lot of data points. If you have backgrounds in databases, you can start thinking how the information can be indexed. Brief civil procedure lesson in the U.S. courts. I promise will be brief. So the way litigation works in federal courts is something called a complaint. You basically file a complaint saying, someone did something bad to me, here's what I'm complaining about. Well, the first thing that happens is someone moves to dismiss the complaint, saying this complaint has no merit. So there's a complaint and there's a motion to dismiss. After the motion to dismiss comes a response to the motion to dismiss. The opposite saying, okay, no, our suit's good. And usually a judge will write an opinion, either granting or denying the motion to dismiss. Okay, I promise we work it. So here we have a case. So we see that on August 12th, 2010, Oracle filed a complaint against Google. And then that little number 1 with a link on it, that's actually linked to the PDF, but that's not too important. Then we know on October 4th, a motion to dismiss was filed by Google. So we know a couple things. First, about 2 months elapsed between the two, and we know all the documents that happened in the interim. And we know that this is how the law firm was filed. We know which law firm filed it, and which lawyers filed it. There's a lot of information which we can glean just from that. Next, we have the memorandum in opposition to the motion to dismiss. So Google moved to dismiss, and Oracle replied saying, no, don't dismiss it. So now we know how long. We know 14 days elapsed. We know which law firm filed this. We know which lawyer, Richard Ballinger. We can find a lot of information about this, which we can just gather. And then, most important thing is the court's opinion denying Oracle's motion to dismiss. It was filed about 3 weeks later. For federal courts, that's pretty quick. We know which judge did it, Judge Alsop. We have the order, we have the opinion with everything. So by just breaking down what it is that the courts do, we can learn a lot. We can crunch data about the cases, motions, opinions, dates, judges, firms, lawyers. You can get all this information straight from this docket, which Pacer is effectively draining into oblivion. And this can be scraped quite easily. So I work with a group called the Harlan Institute. We do some cool stuff. We do the Fantasy SCOTUS, but one product we work on is called Harlan.co. And this is really kind of where big data meets big law. We've kind of put Pacer into an interface that makes sense. And this is just an interface we designed. What we did a backend with Google Docs, where it's all very open source, and we put in all the documents in a specific case. So let's just walk through this. Imagine seeing this instead of seeing Pacer next time we want to research a federal case. So we have our docket overview right here. Here in the bottom, we have a timeline. So rather than just an arbitrary table of random cases that don't really make sense, we have this timeline. See the motions dismissed, we have the complaint, when the opinion was filed. Here we have a preview of the PDF, we have a brief description. All the information that was there is now here in totally scalable form. This can all be used with semantic interfaces. Everything's linked together. It's very neat. And let's just zoom in. We see the motion to dismiss. We go to the bottom. We have this timeline where you can scroll back and forth. This will be very valuable to litigators who want to get a sense of how the litigation proceeds and how everything has evolved. We can also learn about the judge. One of the top questions any client will ask a court is, one of the top questions a client will ask someone is, what's the deal with this judge? What's he like? What's his biography? How does he rule in similar cases? By semantically linking all the different cases that a judge is involved in, you can start figuring out some patterns and trends. The same way we've made predictions about the Supreme Court, we can kind of ascertain what a judge's judicial philosophy is. How does he handle similar cases? Likewise, say you want to look at law firms. Boyce Schiller, one of the top firms in the United States. Just by having everything linked together in this kind of open web format, we can figure out all the cases Boyce Schiller is involved with, or any of the other law firms. Same for attorneys. David Boies, one of the top lawyers in the U.S. What cases is he involved in? What's his win-loss record? How many of his cases go to trial? How many of his cases settle? This is all information that can be gleaned straight from Pacer that's kind of just going down the drain. Likewise, same for Google. Google is involved in this case, and they're involved in a lot of litigation. Right now, it's very difficult for any client to say, what are all the cases that Google is involved in? It's almost impossible. If all this is kind of linked in the same way the National Archives is kind of linking everything together, it's actually pretty straightforward. And I'm actually showing you a brief demo. I've never actually demoed this in public, so I'm hoping it works. See that work? And this is the interface right here. Everything is wide open, and the timeline works pretty cool. So say if you want to kind of scroll through the litigation, you can scroll right through. The motion for summary judgment was filed. Response to the motion for summary judgment was filed. And then the court's opinion granting it. You go all the way to the trial began, jury deliberations, and then when you have a verdict. You can effectively see the entire trial right before your eyes. And at each step, you can view the documents and what's there to see. This is still in beta form, but it's something we're working on. And like I said, it's all built with Google Docs, so it's totally open source. You can view the different judges involved in a case, or frequently in the United States, several judges involved in any given case. The firms, who are all the firms involved. You can view all the cases the firms involved in, all the attorneys, all the statistics about the case. You view attorneys, parties, you view everything. And it's all in one place. And this is really an important way to make sense of this data. Let's see if this works again. Yes. So that's a demo. And if you want, it's at bit.ly/Harlan beta if any of your laptop's open. And I have a brief time left. And I'm going to talk a little bit about the future. Now, Richard mentioned Watson, which is the Jeopardy computer, which is kind of instead of, right now we search for information. We go to Google and we just search for information. The future is helping actually make decisions. The future is actually, you ask a computer a question, it tells you what to do. And this is something which doesn't exist yet. It's kind of a fanciful feature in my mind. But called Harlan, an intelligent litigation assistant. Now imagine an app like you have on your iPhone. Imagine something like Siri, for example. Siri asks it like, what's the weather outside? And it'll tell you. Or where should I go for coffee? And it'll tell you. Instead, imagine you could ask an app like this, I want to draft a contract with such and such specifications. Say it's a contract that you've never drafted before. So instead of just going to a document repository or a template which just gives you templates, it kind of walks you through the process. So it says, okay, I have some follow-up questions. What kind of contract is it? Where will it be executed? What are the possible remedies? And it would walk you through each step of the questions, each stage, so you know how to do it. And at the very end, imagine if you have a document assembly service that says, shall I draft it for you? This is technology which is probably somewhat in the near future where you have document assembly things, where say if you upload different various affidavits and such that the computer can understand, you now have a step where computers can actually do this. Now where this gets really cool is, in my opinion, when you talk about access to justice. If you can actually have an app where lawyers and non-lawyers can do this, imagine a non-lawyer who has this iPhone app and can now figure out how to access justice without needing to hire a lawyer. So for example, you have a landlord, tenant saying, my landlord won't fix my heat. You have this guy that's really cold and he doesn't know what to do. So you have several options. Perhaps there'll be a phone number to link to call the tenant's rights department. Maybe there's a sample demand letter which you can draft. Maybe there's ways in the municipal court to file a pro se suit. Maybe there's a specific housing lawyer that specializes in this kind of stuff that offers low bono or pro bono work. All this can be done totally automatically. And really, you select an option to learn. You learn more about these tools, and the computers help you get there. So what I see as the promise of big data is helping people and lawyers understand the law in a meaningful way where it's not just about opinions and rules of law, but it's actually about trends and data and analysis, and it actually makes sense. All right, thank you very much for your time.